Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to be discussing further issues designed to inform and educate the public, so please subscribe to our channel. I want to talk about appeals, and I want to talk a little bit about family law appeals and what you need to know about family law appeals. And we have touched upon these in a general sense in prior videos, and it has to do with why a person appeals. Let's remember one thing. In these cases, when they go to trial, there's usually somebody who walks away feeling that there's a winner, and there's somebody who walks away feeling there's a loser. Sometimes you think you won, sometimes you think you lost, whatever it is. And then the issue comes up, well, if I feel aggrieved, if I feel that the court didn't hear me out, if I don't like the result, do I get a chance to appeal? Well, there is a Michigan Court of Appeals. The appellate court is there for you. It's there so that you can avail yourself of an appeal if there are reasons for it. But you got to understand one thing. It's not a second bite at the apple just because you feel like it. What it is, and it's a little bit different than like a friend of the court appeal to a judge. Because if you go before a friend of the court for like a hearing and you don't like the result, you can request within a certain amount of days the court to have it, and the court will do what's called a de novo review and hear it again, give you another chance. But the Court of Appeals doesn't do that. The Court of Appeals is not a de novo tribunal where they hear your case all over again and come up with a different one. What the Court of Appeals does is it lets you appeal certain errors of law that were made by the lower court. The lower court heard a piece of evidence and, in your opinion, didn't handle it properly. Maybe they admitted something that you don't think they should have. Maybe they allowed in something that was hearsay that should not have been relied upon. Or the other way around. Maybe they refused to admit something that was properly admitted under the court. Maybe it was hearsay, but it was an exception to the hearsay rule. So those are reasons why the court should or should not allow a piece of evidence. Those are matters of law. These are the kind of things you can appeal. But what outcome can you expect from appealing these things? That's a very good question. The court has different choices. The court can agree with you that the lower court made a mistake, but might find that the mistake was harmless error, meaning that the mistake, while it existed, didn't really change the verdict. Like, for example, you got a dozen factors in the custody analysis. The court may find that the lower court made a mistake as it relates to one of those factors. What mistake might it have been? I don't know. Maybe they skipped it. Maybe they didn't consider it, and therefore didn't consider all the factors. But if the court finds, for example, that that one factor, while omitted, might not have made a difference because it was hands down victory for the other person on the other 11 factors, the court might find that that was an error, but it was harmless error. That's a possibility. The court may agree with you in part and not agree with you in part, and reverse in part and affirm in part. Or the court could affirm the decision completely, which means you lost your appeal. Or the court could reverse, which means you won your appeal. So there are different elements to it. There are different outcomes. If you have any questions about yours, obviously reach out and we'll be glad to give you some guidance in regards to appeals.